Hi, I'm David Rome from Gomez, Radford, and Rome. I'm a criminal defense attorney in Los Angeles, and I wanted to address a few common misconceptions and answer some questions that I've had clients or I've seen people have about the California criminal process. So I hope this video can help a little bit. Do the police need a warrant to arrest me? Generally, yes. The police need a warrant to make an arrest, but there are a lot of exceptions to the rules, so I wouldn't get too hung up on about it. In California, there are vehicle code and penal code exceptions for people to make arrests without warrants in several situations. For example, when a crime is committed in the presence of law enforcement, or if the officer has probable cause to believe that the person's committed a felony, even if the felony didn't occur in the officer's presence. These exceptions allow law enforcement to act swiftly when necessary, but they must still adhere to certain legal standards to ensure your rights are protected, your constitutional rights are not violated. What's the role of the judge in a criminal case? It's important to understand the different roles in a criminal case that the different parties play. The judge is merely a referee, so they ensure that the trial's conducted fairly according to the law. They make sure that the criminal procedure is followed. The district attorney is the one pressing charges, prosecuting the case, not the court itself. It's kind of like if you imagine a civil case, you've got a plaintiff and a defendant. The judge is not the one putting somebody in jail necessarily. That's the prosecution. The DA's office is gathering all the evidence, interfacing with law enforcement, and making their case. The court, including the judge, typically doesn't see any of that evidence until an actual evidentiary hearing. So a preliminary hearing or trial sometimes. That's different from early proceedings like arraignments or pretrial conferences where the court deals with procedural matters and not evidence. I will say there's a very minor exception that during arraignments, a lot of times police will present what's called a probable cause statement, the reason they think somebody should be arrested, with the police report. It's just an excerpt of the police report, basically, or a summary where they explain in a couple of sentences why they believe somebody committed a crime. And that might be used to add context to the complaint when the judge is addressing bail. I'll get into that later. Although it sometimes seems like the prosecution and the court are working together against defendants, technically they are separate entities with distinct roles. The prosecution is aiming to prove guilt. The court is supposed to just ensure a fair process and that both sides follow all the legal rules. What are my Miranda rights? So if law enforcement wants to ask you questions while you're in custody, they need to tell you your Miranda rights. Everybody's heard of the rights, even if they don't know that they're called the Miranda rights. I think it's really important to differentiate custodial versus non-custodial interrogations. So these really only apply if they want to ask you questions while you're in custody. If you're being arrested and the police do not want to ask you questions, they do not need to read you your rights. If you are not arrested, you're free to leave, and you believe a reasonable person would believe they are free to leave. If they ask you questions and you answer them without having your rights read to you, they can use those statements against you. You're walking past the scene of a crime. The police say, "Hey, did you see what happened?" You say something that implicates yourself. Well, now you have gotten yourself into trouble, you've talked yourself into an arrest, and that can be used against you, unfortunately. So Miranda rights, they are only for custodial interrogations where you're not free to leave. These are the common, you see it on TV all the time. Miranda rights include the right to remain silent. You have that right. It's the Fifth Amendment right against self-incrimination. They will make the admonition. Any statements you make can and will be used against you in your case. You do have the right to have an attorney present during this interrogation, and you have a right to have an appointed attorney if you can't afford to hire one to represent you. If the police take you into custody and they conduct that investigation but don't advise you of your Miranda rights, those statements you provide are inadmissible. Case is not automatically thrown out. They might be able to get evidence that doesn't involve your statements and still arrest you and prosecute you. But the statements will be thrown out if you weren't read your rights during a custodial interrogation. What are some benefits to hiring a private attorney versus a public defender? Obviously, I'm biased, but I would like to say, just right off the bat, there are plenty of great public defenders out there. They are attorneys. I've had clients say, I don't want a public defender, I want an attorney. We've all passed the bar. And in fact, although I have prosecution experience, and I think that's very important, public defenders have a great deal of experience compared to people who just went to private criminal defense right out of law school. I would not hire somebody who took that route. Public defenders get a ton of time in court. They have a lot of experience with judges and in trials, and I think that's really important when you're talking about criminal defense. While public defenders are, as I mentioned, often very committed and capable attorneys, they usually have to handle way too many cases at one time, which it significantly limits the time and attention they can give to each client. On the other hand, a private attorney can focus more on your specific situation, giving you more personalized attention and dedicating the necessary time to thoroughly investigate your case and build a strong defense. With a private attorney, you can also expect better communication. That's huge. I get a ton of clients that was their main problem with their other attorney or their public defender, is they just didn't communicate. They have more resources, can access different expert witnesses, and sometimes have more advanced forensic tools too, which can be crucial for your defense. Plus, you get to choose the attorney, and you can choose somebody who has the right experience or a proven track record in handling cases like yours, which can give you a peace of mind and a better chance at a positive outcome. With the public defender, sometimes you will get somebody who's brand new. There's a lot of turnover in those jobs because they're very hard, and so you might get an attorney who's never handled a case like yours versus somebody who, was a prosecutor or works at a firm full of prosecutors like Gomez, Radford, and Rome, where they've handled a bunch of different cases for years, and then they went private and they've handled a bunch of cases for years. You know what you're getting when you're hiring your own attorney. One thing people really misunderstand is the difference between a felony and a misdemeanor. So I think it's also important to differentiate state and federal cases. Very briefly, federal cases are not just more serious versions of standard crimes. When people say, oh, don't make a federal case out of it, I think it's become a phrase and people sort of misunderstand. Just because a case is serious doesn't mean it's not a state case or it becomes federal. That's not how it works. There has to be some federal law broken, and generally that involves things across state lines in different jurisdictions. So trafficking things from one state to another could make a case federal, right? But just the seriousness of the crime. There are federal misdemeanors and federal felonies. In California, misdemeanors and felonies are the two types of crimes that you can commit. And generally, a misdemeanor is the crime that carries just a maximum of 1 year in jail. It's a county jail. It's not a state facility prison. That's the difference. And depending on the severity of the crime, there are fines, usually about $1,000. Could be more. DUIs are significant fines. Common examples of misdemeanors could be prostitution, public intoxication, drunken publics, petty theft, resisting arrest. Felonies, on the other hand, are much more serious offenses with stricter penalties. So committing a felony in California, that could be murder. So murder's not a federal case. It's a felony. It can result in sentences of up to life in prison, without parole, potentially, substantial fines, permanent criminal records that can impact your reputation and future opportunities. There are a lot more felonies that are not expungible offenses. So misdemeanors are generally much easier to expunge, remove from your record. It's also important to know that there are a lot of crimes that can be either a misdemeanor or a felony, depending on the severity. Sometimes DAs have broad discretion in just how they apply that rule. So assaults, for example, are generally based on the severity of the injuries, but it's not always obvious where the line is drawn. For certain cases, for example, theft over $900 is $950, I believe, is the dividing line between a misdemeanor and a felony in California. For vandalism, that's $400. It's weirdly much lower. So if you break a window and it costs more than $400 to repair, which at this point, like, what is less than $400? That's like 3 McDonald's hamburgers. That's felony vandalism. So it is important that we call those wobblers because they can wobble between felony and misdemeanor. And that's something to be aware of when you're arrested, but you haven't yet been charged. An attorney can sort of predict sometimes what you might actually receive or what might be filed. What's an arraignment? An arraignment's your first appearance in court after being charged with a crime. During the arraignment, you will be informed of the charges against you. They might read them out, or they might just give you or your attorney a piece of paper. That's called the complaint, and you're required to be present with some exceptions. Under California Penal Code Section 977, if you are accused of certain misdemeanors, excluding DV or driving under the influence, your attorney can appear on your behalf at the arraignment unless the court specifically orders you to be present. The arraignment is not your opportunity to tell your side of the story. It's not an evidentiary hearing. It's just a procedural hearing where you say guilty, not guilty, no contest. If the court is going to determine bail, that usually will happen here, but they're not hearing evidence against you. What they might hear is the complaint, and they might hear that probable cause statement. There might be some discussion of the facts of the case as laid out in the police report, but it's not an evidentiary hearing. The rules require the court to assume that the complaint is true when they're setting bail, and as a result, they will have to, they'll go into it a little bit, but it's not your chance to fight back. You're not going to win your case. You do not get to explain yourself at this hearing. And in fact, that's a very bad idea. And I'll get to that later. One common question is, when do I get to see my evidence? I was just arraigned. I want to see that video. I saw he had a body-worn camera, and I want to see it. Well, you got to hold your horses. Initially, the DA, the district attorney, they give the complaint and just the first police report on which the criminal complaint is based. Other types of evidence, like those photos or videos, the body-worn camera, the dash cam vehicles, those take longer to get usually. The DA has up until 30 days before trial to hand over all their evidence. I say that, but if they miss this deadline and there's a good cause for the delay, the judge might continue your trial, meaning extend the time before you're allowed to have trial, even if you're trying to push for a speedy trial as a constitutional right, just to give the prosecution time to get the evidence. So they can say, Judge, I've tried to get this evidence. I've requested the body-worn camera from the deputies, and the judge will say, well, that's good cause. If they haven't given it to you, how can you give it to the defense? In my opinion, everybody should be held to that 30 days, the speedy trial standard, if you will. And I don't think that that's fair or good cause to delay a trial if they can't provide the evidence within the time frame. I believe that the law says that evidence should be excluded, but unfortunately judges have broad discretion in what sorts of things they can do to run the trial, and they're aiming for fairness, but it can be very frustrating, and the judges often seem to be siding with the prosecution when it comes to allowing them all the time in the world to give you evidence, but rushing you and your attorneys when it actually comes to reviewing and responding to it. I think it's an appearance of impropriety, and I think judges should be ashamed when they do it, but it happens more often than you would like. One thing a lot of clients wonder is just, why can't I just get up there and explain to the judge that I'm innocent? I mean, first of all, the courts are very busy. It's natural to want to explain your side of the story, but it's important to understand that the court operates under very strict rules. There are certain days for certain things. A pretrial conference is to choose dates to explain what's been going on, explain how the trial is proceeding, but it is not your opportunity to provide evidence. Telling a judge you're innocent outside of the proper procedure can actually harm your case. In court, statements you make can and will be used against you. They're all on the record. The judge is supposed to remain impartial and only consider evidence and testimony presented according to standard legal protocols, like at a preliminary hearing or a trial, right? But you get up there and you make these statements, they're going to take that into consideration, but not in your favor. They are only going to use it against you. Every single person in that courtroom has pleaded not guilty, right? If you're past your arraignment, that's saying, I didn't do it. They already know you don't think you did it. And they're not going to take up the court's time to listen to every single person try and make their excuses. They don't want to hear it. The best approach is to let your attorney handle communication with the court, with the prosecutors. Anytime you're in court, just let your attorney do the talking. If you do testify, that would be during trial, for example. Your attorney can prepare you, make sure your testimony is given in the most effective way. They can't tell you what to say, but testifying at trial is rare, and it's often not advisable. It opens you up to cross-examination by the prosecution, and your attorney can't tell you to shut the F up when you've already opened yourself up to that. Your Fifth Amendment right goes away when you get up there on the stand, and you can incriminate yourself. So there's a lot more to criminal defense than a lot of people realize. It's so important to choose a good law firm from the start when you're charged with a crime. It is so hard because I'll get people who choose a terrible attorney. I had somebody choose a Craigslist attorney, and they spent thousands of dollars on this attorney who had no idea what they were doing. They come to us, and it is so much harder to clean up somebody else's mess. And a lot of deadlines can be blown. It makes the thing much harder. So just from the beginning, be very careful when you're choosing an attorney. Everyone at Gomez, Radford, and Rome is a former prosecutor, so we do know how to win cases. We were winning them as prosecutors, and we actually do fantastic work for our clients now as defense attorneys. We've handled everything from murder to misdemeanors, and we got that murder dismissed. So if you're looking for a good defense attorney in Southern California, give us a call. We offer free consultations because we want everybody to kind of know what they're getting into before they sign up with us. So it literally, you can't afford not to call us if you have any questions. Hope that helps. Hope you have a great rest of your day.